Greetings, everybody. This is Professor Hussein here with Chapter 13, Week 4. And before I start the class, let me go ahead and share the screen with you guys regards to important issues with regards to discussions as well as the assignments. Just give me a second. Okay. Make sure you guys are checking your grades regularly, and obviously now that we are in the midweek of week 4, almost end of this term, make sure you are looking at your grades and checking out all the missing items to complete them before Sunday today. There is no extensions with regards to overdue assignments and discussions. So make sure you complete that. Some of you have not done your midterm, and that you should have done a long time back. Please go ahead and complete them. I have already made it available again. Week 4, you need to complete the discussion assignments, a library assignment which is due, submit a paper, a final paper, which you already obviously gave me your title. That's due, and then obviously the final exam. Make sure you take care of these issues, take care of these things, and then you should be okay. Okay, getting back to the chapter, we'll be discussing airspace and its what we call requirements as far as the state goes, federal government goes, as well as safety of airports go. Obviously, we should become familiar with sources of power available to federal, state, and local governments to deal with problems created by airport development operations. What it means is, in essence, whenever there's expansion, wherever there's new airports in your location, there's always issues regarding noise, safety, and with regards to uh, what the community need to do and what airports need to do for the community when it comes to certain issues. So we will be covering that as well. Although safety is also a major concern for those living near the airport, obviously preponderance of airport accidents occurs within a mile of airports. Most aviation litigation areas of airports and airspace are focused on two problems: airport noise, aircraft noise, keeping airports approaches clear of obstacles. That means, if you look at, I'm sure you guys are familiar with it. You look at the runways, and obviously straight into the runway, which is 5, 10, 15, 20 miles, we have to be really mindful of obstacles to navigable airspace. That means no towers, no buildings, with might with which might uh, pose a we call safety hazard. And obviously, with that comes noise as well. We have to be mindful of that too. All these two noise-related issues are accounted for greater part of this litigation. In those cases, courts struggle to weigh the rights of property owners against interest in safe and convenient air transportation. So for the most part, you'll see a lot of residential areas which are close by the airport, especially older airports. A good example would be Chicago here, which is smack in the middle of the city. You can see communities are right around it. So with a busy airport like Chicago, you're bound to have a lot of noise issues. How does FAA go about mitigate those issues, and what rights do citizens have with regards to excessive noise, and what does FAA do with regards to these issues? Sources of power in the U.S. All public airports have received scheduled and passenger service are owned and operated by state or local city governments or regional airport authorities that have governmental powers. And that includes constitution and efforts to keep approaches clear to these airports, clear of obstructions to minimize costly aircraft noise-related lawsuits from airport neighbors. These governments have relied upon sources of power derived from both constitutional as well as the Constitution of the U.S. and inherent powers as proprietors of these airports, which are considered public utilities. Eminent domain under, I'm sure you guys have heard of eminent domain with regards to highways, byways, roads, and other utilities as well. Under the powers of eminent domain, governments have the right to take private land within the jurisdiction of public use, whether landowner wishes to sell the land or not. The Fifth Amendment to the U.S. Constitution requires, however, that when the government takes private property for public use, it must pay the landowner just compensation. If the landowner is unwilling to sell the property to the government, or if the landowner and government cannot agree on fair prices, just compensation, ordinarily the government files a condemnation lawsuit. A condemnation lawsuit seeks a court order establishing a price to be paid and ordering transfer title to the government upon payment of that price. Police powers is government's right to adopt and enforce laws to protect public health, safety, and welfare. And this regulation, airports and airspace, that is power that has been relied upon by state, regional, and local government as authorities for adaptation of land use zoning, height zoning, and ordinances in vicinity of airport, as well as noise ordinances. The commercial clause of Constitution gives federal government the exclusive right to regulate interstate as well as foreign commerce, is the source of authority for all federal regulation of aviation. Judicial interpretation of extent of this power have uniformly held that because even aircraft involved in purely local flying, such as aircraft observing, reporting highway traffic to local media, crop sprayers, and sports flyers, operate in the same navigable airspace that may be used by aircraft traveling in interstate commerce that could at least theoretically come into conflict with them. The FAA has the power to regulate those activities. The supremacy clause to the Constitution has also something comes into play in these cases. The supremacy clause provides that where the federal government has adopted statute or regulation governing some activity that is authorized to regulate such aviation as commerce clause, then state and regional and local government may enact of, or enforce law conflicting with federal laws. Proprietary powers, in addition to these constitutional sources of power, the governmental entity that owns and operates the airport has a measure of authority as proprietor to regulate the use of that airport as much as owner of private airport would. The power to tax, obviously, governments have the inherent power to impose taxes on person, property, and transactions within their jurisdiction. Taxes are a major burden on every person and business and often key consideration in location or relocation of business enterprises. Increasing property taxes in particular are often responsible for a private airport owner's decision to sell or develop property for some other use. The power of the purse proceeds of federal taxes on airline passenger tickets and aviation fuels have built up multi-billion dollar aviation trust fund. Congress, with U.S. advice, budget expenditure of this money for airport planning, development, and improvement through a program of grants called Airport Improvement Program, AIP. This may include funds to acquire land, aviation easement for noise abatement purposes, to soundproof existing buildings near airports, and then that program federal may be allocated to cover up to 95% of projects. Also remember, many states have similar programs typically funded by airports, aircraft fuel taxes, registration fees, specific ownership taxes, which may provide funds to cover that portion of a project not covered by federal funds. Many states grant programs also provide funding for airport projects that will not qualify for federal funding or for which is not economical to go through federal grant application process. Additional federal fundings are available under military programs for cost of converting military airfield to civilian airport use. Military airport programs funds can be used for some projects not covered by AIP funding, including building, rehabilitation, parking lots, fuel farm, hangars, utility system, access road, cargo building, other airfield project. At the same time, when new airport construction has lagged in the U.S., numerous former military airfields have been successfully converted to civil or joint military use under MAP program. One example is San Jose Ponte de Torres Airport in Cebu, Puerto Rico, and Roosevelt Roads Naval Air Station, which is now civilian airport serving general aviation and several regional aircraft. And also not mentioned here, Scotts Air Force Base in outside of St. Louis, Missouri, has also been converted to a civilian airport. Half the portion, if you look at it, half of it is civilian and the other half is military. Cases involving application of these powers through narrative examination of landmark cases. We will now examine how law governing airports Airspace has evolved to its present state, observing the interplay of powers described above and the legal rights of property owners in the vicinity of airports. And this is a landmark case of power of eminent domain, very first aviation case decided by Supreme Court of U.S. United States versus Cosby, focused on airport and airspace issues. Cosby's were farmers whose principal source of income was raising chickens. Their, their home and chicken coops were located adjacent to a rural airport in North Carolina. That airport was not busy having general aviation activity and a couple of airlines DC-3 flights daily. Then World War II began, the government took over the airport, turned it into a heavy bombing training base operating around the clock with high level of activities. The brains of chickens are apparently programmed to react to anything flying overhead as if it was chicken hawk. Such a perceived threat drives airports into a frenzy of activity. In this fashion, some 150 of Cosby's chickens have destroyed themselves in the process of crashing around their coops in a state of panic caused by low-flying bombers. Eventually, the Cosby, not the chickens, could take no more and hired a lawyer to sue the government. From this humble context would come the foundational laws of airports and airspace in this U.S. In the quest for common law precedent, diligent judges and lawyers could sometimes even search back to times before it became fashionable to publish the judicial decision. A primary valid source of reference to the common law as it existed in earlier times was the writing of Roman gladiators, who around the time of Christ had written rather extensive treatises as on common law. Reference back to this writing, Cosby revealed a century-old facet of common law known as ad coelum doctrine, which when translated from original Latin cucus est solum, states that the person who owns a parcel of land not only the surface of that land, but also airspace above it, literally to the sky. The Supreme Court recognized, however, that the application of this legal principle to aviation institutions would make flights virtually impossible. Each property owner would demand the aircraft keep out of their landowner's space or pay toll for transiting that property. Relying upon Commerce Clause and Congress's announcement in Civil Aviation Act of 1938. Pursuant to Federal Aviation Act of 1958, the court held that navigable airspace is public highway within public domain, and at least it as it would affect the passage of aircraft that ad coelum doctrine has no place in modern world. Court went on to analyze that from constitutional law of eminent domain and terrestrial precedent applying and law to afford causeways some relief for damages they had suffered by holding that in this situation the flights of aircraft owned and operated by federal government so low so frequently to be direct and immediate interference with employment and use of land. Because the value of land was diminished as a result, this operation constituted a taking of private property in the name of aviation easement for public use. So the Constitution required the federal government to pay the landlord just compensation for that taking. Police power in the Pacific Northwest, new regional airport SeaTac was about to be built in Seattle-Tacoma area in an apparent effort to circumvent potential liability for suits for inverse condemnation. Legislators drafting the statute authorized the airport included an elaborate recital to effects that airports were created under police power in the interest of public welfare. When an adjacent owner later filed an inverse condemnation suit, however, the court held that although building a public use airport is certainly a proper excuse for police power, if the effort is to take private property rights for public use, that exercise for police power is also exercise of power of eminent domain. So the governmental entity that owns and operates must pay just compensation to property owners affected by airport projects. Shortly thereafter, Riverside, California, the county was building a new general aviation airport. Ryan Field was concerned that safety and utility of this airport could be jeopardized if the nearby property owners were allowed to erect structures that might block approach paths to the runway. Therefore, in exercise of police, the county adopted height zoning restriction that applied to property near each of the runways to prevent landowners from building obstructions into the landing glide path. Maximum height of permitted proceeding outwards and upwards in stair-step fashion. Only one very low structure will be permitted close to the runways, and and progressively higher structures permitted farther away. Sneed owned a parcel of 234 acres immediately adjacent to the runway threshold. Airport plans predicted airport's noise footprint as it would fall on surrounding lands. The sun level measurements, most commonly used today as DNL, average day and night sound level measure development, U.S. Environment Protection, to permit compensation of noise level for all types of urban sources. It measures ambient noise, including aircraft noise and other noises within the same community setting, and imposes a penalty for nighttime operation. The duration of noise event and aircraft noise that is above ambient background level, it is generally accepted a DNL of 65 or higher is incompatible with noise-sensitive land use such as homes, schools, churches, and hospitals. This one just shows you a map of, I believe this is Orlando. It shows you the noise levels. And increased 10 decibel is perceived by humans as a doubling of noise level. Therefore, airport planners now generally agree that where aircraft noise will be 75 DNL or greater, the land should be purchased outright and included within airport's boundaries. So you can see, obviously, as we go away from the airports, the contours become green or blue because there's less noise. The red area indicates the maximum amount of noise. Injunctions for nuisance. Sometimes residents who are annoyed by proximity of airports seek to obtain injunction from courts to declare operation of airports nuisance and or cease operation. Nuisance is another intentional tort, but generally continuing one rather than an isolated incident. If a court finds a particular activity constitutes a nuisance, court has options to whether award the plaintiff money damages or issue injunction prohibiting continuation of activity that constitutes the nuisance. The power to tax. Local government also have effectively used their power to impose taxes on real property to force out private airports. In a typical scenario, a private property owner establishes an airport in a rural area would well beyond existing boundaries of a growing city. Property taxes, such as areas usually zoned for agricultural use, where airports have been permitted, are usually quite low. But as metropolitan areas grow, residential subdivisions, businesses, and industrial development creep over closer to the airport. Eventually, typically as part of city or countrywide master land use plan, the area will be rezoned to accommodate residential or business development. Proprietary powers, curfews, and restriction of airport use. Meanwhile, back in the West Coast, the city of Santa Monica, California owns and operates Santa Monica Municipal Airport. Originally called Cloverfield, this was one of the Los Angeles' busiest basin's earliest airports, developed long before wisdom of noise-compatible land use planning in the vicinity of airports became recognized. So the airport now appears as an airport carrier afloat in a sea of homes. Acting in its capacity as proprietor of the airport, the city imposed a curfew on jet aircraft operation at the airport between hours of 11 p.m. to 7 a.m. The power of first strings attached grant agreement, where our airport proprietors have accepted federal AIP planning and improvement grants. Assurance in the grant agreement further limits proprietors' latitude to regulate and restrict the use of airports. Most significantly, the airport proprietor must agree to keep airports open for use and benefits of public and all types, kinds, and classes of aeronautical use as on fair and reasonable terms without discrimination between such types, kinds, and classes, unless prohibition, limitation of any given type, kind, or class of aeronautical use of airports necessary for safe operation of airports or necessary to serve civil aviation needs of public. Airport development and its funding is considered a major federal action that may affect the quality of environment, bringing into the play National Environmental Policy Act of 1969, NEPA. NEPA requires preparation of environment impact statement for projects that affect environment. Some states have adopted similar requirements for state and local projects that affect the environment. These requirements may apply to improvements to existing airports as well as development of new airports. Opponents of airport development have achieved some success in courts in enjoining federal funding of airport projects where EIS did not meet NEPA requirements. This one just shows you Orlando International Airport. Airports also require storage capacity of aviation fuel. Therefore, airport planners capacity of aviation fuel. Therefore, airport planner must take into account federal underground storage tanks regulation promulgated under Federal Resource Conservation Recovery Act. Bringing an aging fuel storage facility into compliance has proved major expenses for many airports and has even caused small fields to discontinue fuel services. This one just shows you uh, powers and application and its limitations. Not all solutions to twin problems of airport noise and keeping approaches to airports clear of obstacles have been found in the courts. FAA has been actively involved in noise programs through regulation funding. FAA has been actively involved in noise through regulation funding and procedures. Congress enactment of Airport Noise and Capacity Act of 1990. The first comprehensive federal statute, airport noise requires new air transport designs to be quieter and phasing out of older, noisier jet transport or silencing through engine noise, engine replacement or hush kits. Okay, in summary, publicly owned airports, the government entities that owns the airport can, as a proprietor, impose curfews and other reasonable limitations on the use of airport as long as these limitations are not discriminatory against or unduly burdensome on interstate and foreign commerce and are reasonable. Number two, condemn and purchase land and aviation easements within their jurisdiction in the vicinity of airport through a power of eminent domain and seek federal airport improvement funds to aid in financing these purchases. Number three, impose land use zoning and height zoning on land within their jurisdiction in the vicinity of airport under police powers, but may have to pay just compensation to some landowners if height zoning diminishes their property values. Number four, add soundproofing requirements to building codes applicable to construction in areas impacted by airport noise and pay to soundproof existing structures in that area. Impose passenger facility charges and seek federal airport improvements funds to aid in financing. Number five, enter into intergovernmental agreements with other local governments to accomplish items through 2 to 4 above and beyond jurisdiction of airports owning governments. And, privately owned owners can, number one, purchase adjacent lands or aviation easement over them, but only if the owners are willing to sell. Private landowners do not have the power of eminent domain, therefore cannot condemn or take the property for other private owners. Number two, impose limitation on use of airports without limit unless federal state funding has been accepted, which is not possible for private airports upon open to public where FAA has designated the airport as general aviation reliever airport, needed to draw general aviation traffic away from busy airlines and airports. A citizen can bring suits against airport owner for nuisance and obtain judgment for money damages or injunctions compelling airports to cease operation. Local governments have jurisdiction over properties, can preclude construction of airport by land or use or render the constitute operation of established private airport uneconomical by raising property taxes. Adjacent governments not have jurisdiction over property can do nothing. This is it for chapter 13, and I shall continue with chapter 14 in the next recording. Thank you, and as always, questions, concerns, email me, call me, or text me. Thank you, and have a great day.